2 weeks ago, in a speech to the American Law Institute, Chief Justice Roberts said he wanted to assure people he was committed to making certain that the Supreme Court would adhere to the highest standards of conduct. More important, the Chief Justice acknowledged the court has more to do, that justices are continuing to look at things they can do to give practical effect to that ethics commitment, and that he's confident that there are ways to do that, ways to do more. The Chief Justice is right that there are plenty of ways the court could fix its ethics problems. Bogus personal hospitality, obvious conflicts of interest, phony front group amici, these are all areas ripe for repair. As chairman of this subcommittee, I've pointed out these problems and offered up solutions more times than I can count. But still, we wait for the court to do something, anything, to show that it takes its ethics seriously. The American people are tired of waiting. A new poll released the same day as the Chief Justice's remarks shows that almost 60% of Americans disapprove of the way the Supreme Court is doing its job, and that Americans are more likely to think that the justice's honesty and ethical standards were low or very low. For an institution that depends on the public's faith to carry out its functions, that is unsettling territory. If the Supreme Court isn't going to do anything to restore the public's trust, then it's up to us in Congress. Today, we're going to talk about real solutions to real ethics problems, the Supreme Court Ethics, Recusal, and Transparency Act. This committee has covered at past hearings how the bill would address problems like Justice Thomas's failure to disclose gifts and travel from a billionaire Republican donor. We've also discussed how my bill would create a transparent process for enforcing ethics rules at the court. Today's hearing will focus on how this bill would address recusals and conflicts of interest. From the very first days of this republic, Congress has regulated judicial conflicts of interest to help preserve the judiciary's integrity. Recusal and conflicts laws on the books expressly apply to the Supreme Court. It's time for Congress to step back in to fortify the administration of these laws. Case in point, for more than a year now, Justice Thomas has refused to recuse from cases involving January 6 or the 2020 election. In the first instance, Justice Thomas voted to stop the January 6 committee from getting access to Whitehouse communications that may have included Justice Thomas's wife's texts to the White House Chief of Staff about overturning the 2020 election. The lawfulness of that failure to recuse depends on a fact. What did Justice Thomas know about his wife's insurrection activities, and when did he know it? After more than a year, Justice Thomas has still never been obliged to answer that question. We don't know the answer to that essential fact. In no other court would such an essential question of fact go unanswered. Questions of recusal and conflict of interest are intertwined. So we need to know more about front groups that helped appoint Trump's justices and then appear as litigants before those same justices. And recent reporting shows ties among right-wing operative Leonard Leo, billionaire megadonor Harlan Crow, and Justice Thomas, again often implicated in the filing of amicus briefs without links disclosed. To these concerns and others, the response of the court has been secrecy and silence. My bill would end the practice of Supreme Court justices judging their own conflicts of interest, require better disclosure and transparency so the public knows when a justice has a connection to a party or amicus before the court, and require judges to explain their recusal decisions for everyone to see. As we hear from today's witnesses about why these reforms are needed, we should all keep in mind a maxim so old that it is in Latin: Nemo judex in sua causa. No one should be a judge in their own case.